It gives me great pleasure to actually introduce now one of my own. And this one of my own that I'm introducing is a gentleman by the name of Mr. Vilimile Gumede. He's one of the candidate attorneys here at Snail Attorneys. And he is originally from Swaziland. And when we were conceptualizing this conference, since it was an African conference, you know, Mr. Gumede said, hey man, I really, really want to talk about data protection in Swaziland and the developments there. So here we are now. Over to you, Mr. Gumede. I think I've introduced you.
Thank you so much, Professor Snail Attorneys. Maybe just on a congratulatory tone. Professor Snail Attorneys has recently been appointed as a professor at the university, at one of the universities here in SA, and it gives me obviously great pleasure. Thank you so much for the opportunity. I would like to just maybe just switch off my video at this point and go straight into sharing my screen where I've got my slides. And I don't know, can anybody see the slides?
Not yet, Mr. Gumede.
Okay, so let me try and switch off my video. Let me switch off my video. Like I was saying, thank you so much for the opportunity. This is a topic that I'm very passionate about, thanks to the many interactions that I've actually had with Professor Snail. Is it showing? Thank you. Okay, and where I would like to start is obviously one of the best places to start, you know, the highest laws, the highest law in the land. So in thinking about any topic, you know, within law, whether you're speaking about it in the context of Eswatini or maybe some of the other Southern African countries, one of the major realities is that, you know, there is some common law that is shared amongst the Southern African states, including South Africa and Swaziland. So you find a whole lot of similarities, but maybe just to kick us off, I would just like to, you know, firstly mention that the presentation I'm making is on the country of my birth, a country that I know and love, the Kingdom of Eswatini, which was previously known as Swaziland. Now, most people are only familiar with about 4 facts about the Kingdom of Eswatini. The first is that it's a landlocked country between Mozambique and South Africa. Secondly, that it has a population of less than 1.2 million. And as Professor Snail Attorneys likes to refer to my country as the 10th province of South Africa, it's a small one. Thirdly, you know, people love to, you know, share the fact that they know that it's ruled by an absolute monarch, you know, King Mswati III. So this is obviously unlike the Black Panther situation where you've got King T'Challa who has to fight for his kingdom. Having said that, the fourth fact about Eswatini is that, you know, the king of my country has many wives, but that's not what we're here about today. So briefly, just the legal system in the Kingdom of Eswatini. This is a hybrid of, you know, the Roman Dutch common law, the English law, as well as the customary or indigenous Swati laws. So the constitution of the Kingdom of Eswatini, court justices like to refer to the South African constitution as one of the best in the world. So its status, for example, it is not an act, it was actually Can everybody still hear me?
Have we lost the speaker there? Good. Okay. Hold on. Mr. Gumede?
Can you hear me? Can you hear me?
I think we have you back. Can hear you again. Thank you.
Thank you so much, Prof. So Section 2111 of the Constitution, provides that all proceedings of every court, all proceedings of every court or adjudicating authority shall be held in public. Now, as with any general rule in the law, there will be an exception, and the exception in this case is contained in Section 2112B, which states that a court or an adjudicating authority, where it is so prescribed by a law that is reasonably required in the interests of defense, public safety, public order, justice, public morality, the welfare of persons under the age of 18 years, or the protection of private lives of the persons concerned in the proceedings, exclude from its proceedings persons other than the parties and their legal representatives to such extent as is so prescribed. So that is the general, if I may call it a general exception that applies to the provision that relates to public hearings. Now, the broad protection of the right to privacy contained in Section 14, at this juncture, I'd like to venture into a brief discussion of some of the laws, of some of the cases that have actually been heard in our courts. So in the case of Swaziland government versus Aaron Gomane, the right to privacy featured as a component of the concept of injuria or injury, which is a general delict that covers a variety of rights, such as one's right to a good name, or one's right to dignity, one's feelings of chastity, liberty, life, property, or reputation. So the Supreme Court basically had to decide whether, there was a proper claim for damages in respect of these rights that I've just mentioned. Now, in the context of data protection, this right to privacy, or this case in particular, is kind of insufficient to actually give us an exposition of the right to privacy in any other context other than the law of delict or the law of damages. All that it shows us is that the right to privacy is just as important as the other rights that are comprised in injury, or that may be covered by injury. And in the case of Dumisani Wiseman Shongwe versus Principal Magistrate Sitegi, so Sitegi is just one of the towns in the Kingdom of Eswatini. In this case, the court basically had to perform a balancing act between the interests of the individual, in this case, Mr. Shongwe, as well as that of the state. And the conclusion that the court came to in its obiter remarks was, making a citation of another case where it said that the court found that there are safeguards protecting the right to privacy, and that the scope of limitation of this right is quite narrow. So in the number of cases that we find from the Kingdom of Eswatini, privacy has actually been dealt with mostly in criminal actions and intellectual claims, but the important question always remains, are there any threats to the right to privacy of individuals online, even organizations, companies, businesses, or in their use of the internet? Does that exist in the Kingdom of Eswatini? That question remains, So the concern within data protection of privacy on and offline, as well as the protection of personal information, these as global concerns, just for everybody around the world, are not any exception insofar as the need for regulation is concerned, even in the Kingdom of Eswatini. So in this slide, I cite, one of the cases that I've come across, happening on social media. This is not something that has, found actual litigation in the courts, but it's one of the many cases where you find somebody selling a property that does not belong to them, and basically it's a scam. So this obviously then speaks to cybercrime, to cybersecurity, but the essential point within this context is that there are people on seeing a house, being sold for 75,000 emalangeni, that converts also to 75,000 rand. The dollar value, maybe for those of us that are not from within Africa, you just divide that by 17 and you'll get the value. So a bunch of people purchase this property only to find that the person that has sold it to them doesn't actually own it, and they've provided so much of their personal information in relation to that actual purchase. So this is just to demonstrate that, the right to privacy, it really needs regulation even within the Kingdom of Eswatini, and there are some data protection and privacy concerns. So there are other data breaches that have actually occurred in the Republic of South Africa, and some of the common ones, I think my principal, Professor Snail Attorneys, had actually mentioned, Experian, which is a consumer or a business and a credit information service agency that indeed experienced a data breach. There are other well-publicized ones, such as, the Liberty Insurance one, where confirmation was actually provided that personal information of Liberty's clients had been breached. There was also the View Fines data breach, where the driving licenses of just under 1 million people who are road users, who had entered their names, personal identity numbers, email addresses, etc., in plain text on the View Fines website were breached. Now, you may ask yourself, what does this have anything to do with, the Kingdom of Eswatini? Like I mentioned before, a lot of people will consider the Kingdom of Eswatini as, the 10th or the 11th or 12th province of the Republic of South Africa, depending on whether you're from Botswana or Lesotho, maybe even maybe even Zimbabwe. So people who are from Eswatini have tons of relatives in the Republic of SA. A lot of them live in SA. People have invested in property in South Africa, and this is why maybe at this point I would mention the data breach at the Master of the High Court as well as the Deeds Registry. People's personal information who are from the Kingdom of Eswatini are in fact at risk with these data breaches that have occurred. But this also further highlights the fact that this is indeed a possibility even for us in the kingdom. Now, the salient pieces of legislation, I would like to now turn to the salient pieces of legislation that actually have a bearing on data protection in the Kingdom of Eswatini. So firstly, we'll have, the Constitution, which, as I mentioned, is actually an act of Parliament enacted by the King together with Parliament. Then there is the Swaziland Communications Commission Act 10 of 2013. The reason that I cite it as such is because that is the name that it was given at the time when it was enacted. So the name Eswatini only featured very recently. Then there is also the Consumer Credit Act 7 of 2016. And most importantly, then the Data Protection Bill 21 of 2017. Now, if you've had any interaction with any of the acts in South Africa, you will know that, for example, the Consumer Credit Act is similar to the National Credit Act. I believe it's Act 34, 2005 of the Republic of South Africa, as well as, this 2013 Act of Swaziland may have similar provisions to the ECT Act, or Electronic Communications and Transactions Act of South Africa. I will speak a little bit to what the differences are insofar as they relate to data protection at a later stage. So the Data Protection Bill of 2017, that's just the preamble. It was enacted to establish the Data Protection Authority, as well as to provide for the principles of regulation of processing of personal information in order to protect and reconcile the fundamental and competing values of personal information privacy. So at this point, I'd like to move on to some of the important definitions. Having made reference to the Protection of Personal Information Act, as I heard Prof. Snail Attorneys, as well as Dr. Lucena, or was it Professor Lucena? I'm so sorry. I might have I might have a slip of the tongue there. But the point that I'm trying to make is that the definition of these various actors. If you look at data controller, data processor, data subject, those are inherited from the Data Protection Act of the UK, and then obviously at a later stage, GDPR. So a data controller, just as it's defined, similar to what the wording that you'll find in the Malabo Convention, which was mentioned earlier, as well as the SADC Model Law on Data Protection, is a public or private body or any other person which or who, alone or together with others, determines the purpose of and means for processing personal information. So the definition goes on from there, but I think we get the picture. Various government entities, various companies, various people to whom data subjects will come and give their personal information for whatever purpose. So then a data processor is defined as a natural person, a legal person, or a public body which processes personal information for and on behalf of the controller and under the data controller's instructions. So here we see, for example, from the law of contract, the idea of agency here. The data processor and the controller are different, but the data processor provides a service to the controller under the controller's instruction. Then a data subject refers to any individual who's the subject of the processing of personal information and who is identified and identifiable. So it's you and me, a person with a name, a surname, an ID number, and so on and so forth. And then processing is also given a specific definition, and you'll find that this is also consistent with some of the international laws or some of the foreign laws, such as GDPR and similar wording also with the Protection of Personal Information Act. At this point, if I may perhaps move on to the Data Protection Authority, which is established in terms of Section 5 of the Data Protection Bill 21 of 2017. And in this section, there's a very interesting part which is found at Section 6.1 as well as Section 6.2. But if I may read Section 6.2, it'll say that the Data Protection Authority Board shall be composed of not more than 7 members who shall hold qualifications in law, human rights, information and communication technology, or who are prominent members of society. Now, this is also the issue or concern that was raised by the previous speaker. For example, you'll find that last bit that says who are prominent members of society. Now that will mean anyone, depending on where you are. But I suggest that in the Kingdom of Eswatini, this implies people who are, connected to the monarch. Then the sections 24 to 37 deal with, the conditions which Advocate Ntatisi Asare mentioned earlier, the conditions or guidelines or principles, for the lawful processing of personal information. And these, as I'm pretty sure we all have an idea, are accountability, or they include accountability, processing limitation, purpose specification, further processing limitation, information quality, openness, security safeguards, as well as data subject participation. Now, I will attempt to be as quick as possible because of the time limitation in discussing. Okay, so the host is now making me aware that I've only got about 5 minutes left. So I will skip over those because they are kind of common cause, and I will perhaps share these slides for anyone that would like to have a look. So we've got the conditions of accountability, where I discussed to say that in general terms, it entails the accountability principle and aims to ensure that the obligation imposed by a particular data privacy law is actually given, teeth and effect. So let's skip over those. And then in terms of enforcement, I've already made mention of the Data Protection Authority in the Kingdom of Eswatini. But you know, the Data Protection Bill of 2017 provides that provides for a complaints procedure similar to any of the other data protection authorities or the information regulator in South Africa, for example, which will handle, you know, investigating as well as giving enforcement notices, reviewing, and appealing by the persons who will actually have brought those complaints. Now, the nice thing also, maybe for those of us in the legal profession, the importance also not just of, you know, tech professionals, but also for legal professionals, even in the Kingdom of Eswatini, is to get acquainted with the Data Protection Bill, in that there are some civil remedies that are actually created in terms of the Data Protection Bill. So trans-border flows, again, Advocate Ntatisi Asare made mention of this, and perhaps if I may make mention also of, you know, Section 70 of the Data Protection Bill, which basically provides that, you know, personal information will only be transferred to recipients in member states that have transposed to the SADC data protection requirements. So we usually look at GDPR as, you know, the international best practice and the obligation that will normally be imposed upon actors outside of, you know, the European Union is to be GDPR compliant. And in the case of, you know, the Data Protection Bill of Eswatini, it makes mention of the SADC data protection requirements. And obviously then this speaks to the SADC model law on data protection. Then I've already made mention of GDPR, the Malabo Convention, which Professor Sizwe Snail Attorneys also alluded to. If you take a look at, for example, Article 9, it states that, you know, the convention is applicable to data processing undertaken by a natural person, so that's you and me, within the exclusive context of his or her personal or household activities, provided, however, that such data are not for systematic communication to third parties or for dissemination. And then we are aware of the SADC model law, which is brought about by the HIPSA project, or otherwise known as the Support for the Harmonization of the ICT Policies in Sub-Saharan Africa. Now, they held a meeting on the 28th and the 29th of August, and Eswatini also got an opportunity to table whatever legislation they would be enacting to ensure that we are also compliant, or we are also in tune with the SADC model law. And then I would just love to conclude by saying that, you know, the concept of privacy is clearly protected by the Constitution of the Kingdom of Eswatini. And this we will find in various sources in literature to demonstrate the importance of this right. But the protection of data, as well as the right to privacy, the subset of which is the protection of personal information, is clearly a fundamental right which the government of Eswatini must be concerned about protecting. And at this point, perhaps I should mention that the bill to this day remains a bill. And I did mention that it's a bill from 2013. So that's about 7 odd years that this law has actually been, you know, written down, and it's since been in the pipeline. So the Cyberlaws of Eswatini are presently either, you know, inadequately existent or in the pipeline, and this presents a threat not only to the fundamental right to privacy, but also to state resources, thereby creating a need for expeditious promulgation and implementation of legislation, regulations, regulatory bodies, alternative dispute resolution agencies, etc. So I think let me just end there. I have seen some signs. Thank you.
Thank you very much, Mr. Gumede, for a very, very interesting presentation of the Kingdom of Eswatini, as it is now called. Very, very small country, yet doing very, very big things. Reminds me of Rwanda when it comes to ICT issues and being advanced with the times. One of the African countries that is definitely up to scratch. I see a comment here from Jareed Pillay. He says, thank you very much, Mr. Gumede. That was a fascinating presentation. I can only concur with you. Are there any other questions from the floor at this stage? Let me see. Any last question? All right. I guess that's it then, Mr. Gumede. Oh, no, I see there's something. Oh, Mr. Gumede, yes, appreciate it. Yes, we appreciate you as well. Aha, there we go. Advocate Chikalangi, is there a DPO in Swaziland, in Eswatini? My apologies.
Oh, okay. As I mentioned, the Data Protection Authority, that's a body that's still, in the pipeline. But when the HIPSSA project was tabled, the ITU international organization is the one that's kind of spearheading talks around data protection in the Kingdom of Eswatini.
Thank you. Okay, I guess that deals with that. I see there's a question here from Michael Patchett Joyce. What were the dates of the cases you referred to? Over what periods have the court in Eswatini been developing privacy protection?
Okay, so I cited these 3 cases, and for example, the Dumisani case, that was from, just give me a second, please. The Shongwe case these are not all, new cases. These are not all new case law. And like I mentioned, they relate either to criminal law or they relate to delict. So Swaziland government versus Aaron Gomane, that is a 2013 judgment. Dumisani Wiseman Shongwe versus Principal Magistrate Stegi, that is a 2014 judgment. And then in that same judgment, the court actually referred to a 2001 judgment. So in terms of, case law, for anybody that is interested in, finding out more, you could also visit, much like, you can actually find a lot of them on SAFLI, but Eswatini has its own database of case law and judgments, and that will be found on Swazili. So that is Swazili, Swazi, SWAZI, LII. I'm not sure now whether it's a .com or a .co.sz, but that's the website where you can find more case law. Alternatively, we can also be in touch. I can provide my details, and then I can just provide like a nice comprehensive list of, case law that has spoken to privacy and data protection.
Last question there from Advocate Chikalange. Is there anything to do with cybersecurity in Eswatini at the moment that is effective, just to understand the status of privacy and security? That's the last question so that we can get to the last speaker.
Okay, so the Swaziland Swaziland Communications Commission Act, the one I mentioned earlier, which is, sort of similar to the ECT Act in South Africa, was actually enacted, to establish a communications commission, as well as to regulate, its functions with regards to electronic communications, data protection in electronic communications, postal services, electronic commerce, and broadcasting. So its functions have mainly been, comprised of licensing for radio and television, whereas data protection, which is, I guess, the more pertinent issue to which government must implement statutory provisions, is basically still on paper. And then this is obviously not the case with email communications, in that individuals tend to assume, for example, that they enjoy some magic protection from unintended recipients when they communicate via electronic mail. And the issue, for example, of e-signature is also not covered in the ECT Act. So to answer your question, we've got about 3 bills, you know. There's also the cybersecurity bill, and the cybersecurity bill, interestingly enough, is also from 2017, like the South African one. I hope that answers your question. Thank you.
Thank you very much, Mr. Gumede. A very insightful presentation. That actually then concludes the data protection session for today. We got a message earlier that Mr. Mohapi unfortunately cannot present today. But in order for the program to continue, we will then start with session 2, which is